City, the smartest people, the biggest ideas.
Irwin Cotler was first elected to Parliament in Pierre Elliott Trudeau's old riding of Mont Royal, my own actual original riding of residence in Montreal, with 92% of vote. He was elevated to cabinet in 2003, and as an old pal of his, I'm proud to say that he ushered in same-sex marriage after appointing 2 women justices to the Supreme Court. Irwin first came to public attention as an international human rights lawyer defending political prisoners such as Sakharov in the Soviet Union, Mandela in South Africa, Timmerman in Argentina, and quite a few others. Equally, and with regard to Darfur, he reminds us of what the sages have said: if not now, when? And if not me, who? Irwin?
Thanks, Moses. I'm going to try and begin with a little bit of levity that my son obliges. He always requires me to expose this to you so you'll know who is the real person standing before you if I get an overly generous introduction, the kind of false advertising from a good friend like Moses Namer. And in order to share this with you, I have to make full disclosure at the outset. And in a conference like this, one is embarrassed to say this. I happen to be technically illiterate, or to use the politically correct term of the day, technically challenged. I don't know how emails or computers or videos work. Well, my son, who's now 19 years of age, came to me when he was about 3 years of age, and this story has become legendary in our family, and he came to me one day with that impish smile which became his trademark. He said, "Daddy, can you help me fix the video?" And I looked at him and I said, "Well, Yoni, you know, I don't know how to fix the video." And he said, "I know, Daddy. All I'm asking you to do is to pick me up because I can't reach it." Whereupon later that day, my daughter, Gila, came to me and said, "Daddy, do you know what Yoni told me?" And I said, "No." He said, "Gila, Daddy may be a nice man, but he's not very smart. He's not very smart." So I figured I'd give you this riposte to what Moses said. And he also said something on that 92% vote, which I'd like to share with you. He was utterly opposed that I run for Parliament. And he was 12 years of age when I did run for Parliament. And at the nomination meeting, he was walking around forlorn, and a journalist saw him and he said, "Well, what do you think of your dad running for Parliament?" And he answered as follows. It was the front page of the newspapers the next day. He said, "I think my dad's crazy." He said, "He's a law professor, he's in human rights. That I can understand. What does he want to go to Parliament for?" This was about 7 years ago. He said, "Nothing ever happens there. They don't do anything. If anything, some of them become corrupt, and there's a Monica Lewinsky waiting for him around the corner." Actually, you should have invited him rather than me. 6 weeks later, and that's the only way, at risk of sounding self-serving, the only way I can tell this story when I did get 92% of the vote, as Moses said, this same journalist calls up my son. He said, "What do you think of your dad now? He got 92% of the vote." And he answered him as follows again on the front page next day. He said, "Donald Duck running in this riding for the Liberals would have gotten 92% of the vote." He said, now if my dad lost, that would have been a story. One little other thing that he said, whose profundity I began to appreciate, after I became a minister and some 6 months into it, he turned to me one day, he said, "Daddy, let's face it. When you were a law professor and you said something," he said, "people believed it because they respected law professors. Now you can say the same thing, and people don't believe it because we don't respect politicians." What I'd like to do with you is share with you some ideas about justice, about the pursuit of justice, which my late father, whom Moses knew, used to always remind me of that biblical injunction. He used to say it to me in the Hebraic, "Tzedek, tzedek, tirdof," justice, justice shall you pursue. And he would tell me that this was equal to all the other commandments combined, which is probably why immediately after being sworn in as Minister of Justice, when we were ushered out for the proverbial media scrum, I said that I would be guided in my work by one overarching principle, and that of justice, justice shall you pursue. And I said within that, the promotion and protection of equality not only, though it is certainly that a central principle in the Charter of Rights and Freedoms, but equality as an organizing principle for the building of a just society, and the promotion and protection of human dignity, for the building of a society that is not only justice, but one that is compassionate and humane. And so I thought to myself, if the pursuit of justice was to be an overriding priority, I ought to go around Canada, visit all the regions of Canada, talk not only to my counterpart, provincial attorney general, members of the legal profession, bench and bar, law schools and the like, but to speak about, with Canadians from all walks of life, particularly younger Canadians, to put to them the question, if you were Minister of Justice and Attorney General of Canada, what do you think the priorities should be, or the principles that should underpin those priorities? As before I began my trip, there was a group of Aboriginal students, Aboriginal law students from Nunavut. They had come to Ottawa for a training session. I was invited to meet with them, and it was a fascinating encounter, one in which I learned something else, or was reminded of something else that my father taught me, that if you want to pursue justice, you have to have a feeling for injustice. You have to understand, you have to feel the injustice around you. Otherwise, it's just a matter of abstraction. These students came and they said to me, Professor Cotler, we're not just law students. We're Aboriginal law students. We come with a past, with a history, with a heritage, with a language, with a culture, with an identity, with our own Indigenous legal tradition. And we've been dislocated from all that. We've been dispossessed from our land, from our culture, from our history, from our heritage, from our language, from our identity, from our own Indigenous legal tradition. And they said, it's not that we go to court because we want to continuously nurture a grievance. We go to court because we want to reconnect to who we are. We go to court because we want to reaffirm our roots. We go to court because we want to reassert our own Indigenous legal tradition. But wherever we go and in whatever we do, we're accompanied by a great sense of pain that you and the government, the people of Canada, just don't understand. And I said to them at that point that I'd like to share with them a parable which comes out of my tradition, but come from other traditions as well. So that's where a group of students go to their rabbi and they say, Rabbi, we love you. And the rabbi says, do you know what hurts me? And the students say, Rabbi, why do you ask if we know what hurts you, if we tell you we love you? And the rabbi answers, because if you don't know what hurts me, you can't tell me you love me. That's a rather profound principle of human relationships. And I said to them, I will try, I can't expect, it would be presumptive to try to understand, let alone feel your pain, but we will try to govern ourselves with respect to relating to your own historical experience. And that, of course, inspired our own, while I was minister, kind of 8-point approach to Aboriginal justice. But then I shared with them something else, and I told Simcha Yakubovic that what he said yesterday reminded me of this, and I'll share that with you, because I too, like him, feel very much historically embedded in a kind of 3,000-year-old culture. And as I say this, I respect, in a parallel sense, other Indigenous cultures and traditions in the same way. And I said to the Aboriginal law students, I said, at the risk of appearing to you somewhat presumptive, I said, let me just tell you that I come from a people that still inhabits the same land, embraces the same religion, studies the same Aboriginal covenant, the Torah, speaks the same Aboriginal language, Hebrew, and bears the same Aboriginal name, Israel, as it did 3,500 years ago. Whereupon a number of them came up to me after and they said, welcome one Aboriginal people to another. And there's something in that. And that is that if you speak authentically, if you express yourself in terms of your own authentic identity, then you can have a real, genuine conversation. Then you can have a real, not just joinder of issues, but a real joinder of experiences and values and hopes and aspirations. We need to give, in our domestic courts in Canada, a domestic remedy to the victims of torture and terror.
It's just really authentic, and as a result, it really moves you.
Let me now just move to 3 basic ideas in the pursuit of justice. The first is the importance of the promotion and protection of the Canadian Charter of Rights and Freedoms. I think we need to appreciate that the advent of the Charter of Rights and Freedoms has had a transformative impact not only on our laws, but on our lives. That we've moved from being a parliamentary democracy to being a constitutional democracy. The judges have moved from being simply the arbiters of interjurisdictional disputes and legal federalism to judges being the guarantors of our human rights because we, Parliament and the people, invested in them that authority. And where individuals and groups, people ourselves here, move from being passive objects of a legal federalism powers process to being rights claimants, to being rights holders with a panoply of rights and remedies that would have been inconceivable prior to the Charter. And that's why if you go around this country and you ask women and the disabled and minorities and aboriginals and refugees and immigrants and the like, are you better off now than you were before the Charter was enacted? The answer is invariably yes, with all its inadequacies, with all its imperfections, because the Charter is not only a text in abstract language, the Charter really is an instrument for the promotion and protection of a just society. And that Charter in some places and in some quarters is now under, at times, critique and attack. And we have to be sure as citizens, and in terms of those for whom the Charter has been created, that we maintain the narrative of the importance of the Charter as an instrument for the promotion and protection of human rights, Aboriginal rights, and the like. Bringing me now to the second idea, and that is the whole question of the relationship of terrorism and human rights. I don't see that there needs to be any real contradiction between the protection of security and the protection of human rights. It need not be an either-or, zero-sum analysis. In other words, what we're really talking about here is the protection of human security, which embraces both national security and civil liberties, and has a two-pronged rights perspective. The first is that terrorism, particularly transnational terrorism, has to be seen as being an assault on the security of democracy and an assault on our individual and collective rights, whoever we are, of whatever ethnicity, nationality, or religion, our individual and collective rights to life, liberty, and security of the person. In that context, and from that first human rights principle, anti-terrorism law and policy should be seen as the promotion and protection of human rights, as a promotion and protection of human security in the most profound sense of the word. But now we come to the second part of that duly pronged human rights approach, and that is the enforcement and application of anti-terrorism law and policy must always comport with the rule of law. Torture must everywhere and always be prohibited. Extraordinary rendition must always be regarded as impermissible. Individuals and groups should never be singled out for differential and discriminatory treatment in the enforcement and application of law. In a word, in the course and for the purpose of protecting human rights, we cannot undermine human rights for that purpose. And that's why I say that the Grundnorm principle here is that of the protection of human security, which embraces both security and human rights. I want to say also in that regard that there are three things that need to be seen here. And sometimes I say we need a dual model approach with regard to terrorism and human rights. The first is the conventional domestic criminal law due process model, where we realize that all suspects, including terrorism suspects and I defended political prisoners who were accused of acts of terrorism, that have due process rights, whether it's protection against arbitrary arrest and detention, presumption of innocence, the right to count, etc., etc. That's one model. The second model is what I would call an international criminal justice model, where we realize that these transnational acts of terrorism are not just your conventional acts of violence, but they really slide into what might be called war crimes, crimes against humanity and the like. And in that context, every state has a duty within domestic and international law to protect its citizens, and to do so pursuant to domestic and international law. And this includes not only holding the terrorists to account, it includes also holding the government perpetrators and officials to account for the perpetration of torture and terror. And that's why I appeared today in the op-ed of the Globe and Mail with regard to holding Iranian officials implicated in the Kazemi case, which William Sampson spoke about, holding them accountable. It's a mocking assault on human rights that two of the officials implicated in the Kazemi case, in the torture and brutality with regard to other citizens in Iran and beyond, should have been members this week of the official Iranian delegation to the inauguration of the new United Nations Human Rights Council. That makes it a scandal of human rights. And our government has to speak out and say not only should they not be permitted to sit on a delegation, on a UN Human Rights delegation, at a UN Human Rights Council meeting, they have to be brought to account for the perpetration of their crimes. And a related thing which I started to work on while I was minister, and the election interrupted, but I believe the government is going to continue, and that is that we need to give, in our domestic courts in Canada, a domestic remedy to the victims of torture and terror so they can sue their perpetrators in domestic courts in Canada, so nobody can be held immune from liability for the commission of these acts of torture and terror. Things occurred historically because of crimes of indifference, because of conspiracies of silence.
I think everybody opens their eyes, and I think one of the best parts is I'm always surprised by the ones that I find the most interesting. You think, oh, I don't know anything about that, not going to care, and then you walk in and you're blown away.
Let me close with the third thing, and important thing, and that is the combating of mass atrocity and impunity. In other words, the building of an international justice system for the 21st century, whose first component is the combating of mass atrocity and impunity. You know, one of the enduring lessons of the Holocaust and of the killing fields thereafter is that the Holocaust, the unspeakable genocide in Rwanda, I say unspeakable because nobody could say that we did not know. We knew and we did not act. Just as in Darfur, no one can say that we did not know or we do not know. We knew, we know, and we are still not acting. These things occurred historically because of crimes of indifference, because of conspiracies of silence, because of people who were not prepared to stand up and be counted, but who were looking around to see whoever else was standing before they made a judgment to do so. And I want to say now with regard to Darfur, after the horrors of the Holocaust and the Balkans and Rwanda, in Darfur, we still have a chance. In Darfur, we need to stand up and be counted. We have to, indeed, the time has passed of shattering the silence, as the students say, of screaming for Darfur, of breaking down these walls of indifference and these conspiracies of silence. But it's not enough just to raise our voices and sound the alarm, though that is certainly necessary. What we need is an action plan in order to protect people on the ground. And that's why a number of us have proposed a 10-point action plan. I won't go into it other than to say that we need a multinational protection force under a United Nations protection mandate that authorizes it to protect and to put an end to the killing. That's what the responsibility to protect doctrine was all about. But it cannot just be a matter of words. It has to be a matter of deeds. And until such time as we can put that multinational Chapter 7 UN protection force on the ground to stop the killing, we have to augment the African Union force with the necessary numbers and the mandate and the capacity and the resources to stop the killing, to be able to deliver the humanitarian assistance, to protect the aid workers, and to put an end to this kind of scandalous situation. You know, one of the worst things that occurred on this, and it's something that, you know, it says something about why the thing has ironed me so much. You know, the entire election campaign, not one of the four leaders of any of the parties, I include the leader of my own party, not one mentioned the word Darfur in a 6-week election campaign while the killing was going on. Not one media person put one question to any of the four political leaders about Darfur while the killing was going on. And I want to say that in the last 4 months, we've actually had more people displaced, over 250,000 people displaced in the last 4 months than in any other comparable period. That the killing goes on now with an intensity, along with the rape and the pillaging, in a manner that is, which already was without precedent and parallel before. But it's off the radar screen because we heard that there was a peace agreement, and therefore it goes off the radar screen. And you can't allow subterfuges sometimes as alleged words on paper that nobody seeks to abide by to keep us from doing what needs to be done in terms of stopping the killing. And in the campaign, whenever I spoke about Darfur, I saw the eyes glaze over of the media and the like. And so I just want to close on this and to say that each one in this room, we each take it upon ourselves, each of you takes it upon yourself to just tell, engage, involve 5 people, 10 people to act to stop the killing in Darfur. Then as a result of this conference alone, we can maybe have a critical mass of 15,000 people that will be raising their voices, that will hold the government accountable, that will get the international community to move on Darfur. You know, in the end, and I'll end where I began in terms of justice, justice shall you pursue. In the end, the pursuit of justice is not just an abstract notion. Pursuit of justice is what we each do every day in our own lives, in our own families, in the workplace, in the marketplace, wherever, whatever we can do every day on behalf of some victim of discrimination and disadvantage somewhere. That is what the pursuit of justice is all about. Now, Maimonides tells us that the world is divided equally almost into good and evil, which tells you that by one single act, by one person, you can tilt the whole universe in favor of good as against evil. So we, each of us here, can be, in a sense, a private attorney general in the pursuit of justice. Each one of us here can help to advance one by one the cause of justice. In a word, we don't have to dream about building a just and compassionate and humane society. By our own individual and collective action, we can help build it. Thank you.
Get the latest Idealist news, presenter information, and watch streaming video at www.ideacityonline.com.